My Lords, I too put my name down on Amendment 97 that would introduce yet another impact assessment. I know that so many impact assessments have been proposed in relation to this bill that it's become a bit of a cliche, but I'm especially concerned that this one is taken seriously, as I do think that the third-party harassment sections of this bill are potentially ill thought out in a way that could lead to unintended consequences. The Noble Lord, one Noble Lord a few moments ago asked why there was a desire for an impact assessment rather than thinking of the potential positives of this bill. But I think that the response of the government in relation to concerns about, for example, Clause 20, which is to say that there's nothing to see here, there's just no problem at all, would indicate that that is an insufficient way of responding to some quite detailed scrutiny that has been put forward. And I think that if it's the case that there's any exaggeration of the potential problems, then an impact assessment should be able to resolve that for us. I'll focus largely on the Clause 20 and firstly look at its potential costs to employers, especially important as the Minister's counter to my remarks earlier was that Clause 20 will be good for business. The government's minimal assessment advises the government's own assessment advises the total economic impact of complying with Clause 20 will be under £10 million and will have negligible economic impact on businesses. I really do think that this is irresponsible. I mean, some might go so far as to say misinformation. For example, in that assessment, it says that the cost of familiarisation with the bill and its ramifications will be £30 per medium business and only £19 per small micro business. I don't know, I'm not sure where these kind of woeful underestimates come from or what they're based on, but I can assure you, if you've ever met an employment lawyer, that's an unlikely figure. We need a serious cost-benefit analysis because let's consider what this bill requires businesses to do, the section of the bill that we're looking at. Employers must show that they've taken all reasonable steps, which sets a high threshold, by the way, for preventative actions, as we heard earlier. And think what that means. There's direct costs for initial implementation of anti-harassment policies, including familiarising themselves with the new regulations, checking out exactly what their legal liabilities will mean. And as we've seen this evening, it's not necessarily clear as day what this bill requires. We've been arguing here. If you're a small micro business trying to concentrate on, by the way, being a micro business and maybe growing into a bigger than micro business, having to kind of study this bill and work out what your liability will be could be quite time-consuming, nerve-wracking and so on. So they'll have to seek out legal advice, third-party advice. No doubt there'll be lots of consultants queuing up because they'll want to safeguard themselves from the financial risks of not complying, which is because they're responsible businesses. And one of the main risks that they'll be trying to ensure that they don't have to deal with is the possibility of employment tribunals. In what seems like an entirely arbitrary figure, the government predicts that only 30 employment tribunals a year will come from these clauses. I mean, there's no explanation as to how the government reached that figure. And it seems and it's certainly completely at odds with industry experts who expect that Clause 20, just Clause 20, will see an increase in employment tribunals of 15%. In other words, an additional 14,750 cases a year. And as we heard earlier in a different context, already in the years 2023 to 24, employment tribunal courts received 97,000 cases, up from 86,000 the year before. So that's already an increase of nearly 13%. More and more people are being forced into employment tribunals for a variety of reasons. And now this bill threatens to create even more cases An unknown figure, because we don't know, and it's a new clause. And so, therefore, you know, the government's saying, oh no, it'll only be 30 a year. I mean, that's just making it up. And there's at least an attempt in this amendment to try and work this out. And I think that when you consider, crucially, that according to the Chamber of Commerce, the cost of one employment tribunal is on average about £8,500. And, by the way, if a claimant is successful, there's no financial limit to the compensation in a harassment case. So imagine you're the business and you're worried about what's going to happen. This will lead to risk-averse, over-cautious behaviour that's not spelt out, detailed in the bill, but in order to try and avoid being held liable, we fear, some of us, that this is what it will lead to, this kind of over-regulatory precautionary approach. So businesses won't be able to be slipshod about their potential liability, and for those smaller SMEs and micro businesses, often with no dedicated HR or EDI officers, they'll need to think about employing new staff dedicated to protecting them from claims, giving them advice. And I mean, you know, the idea of a whole new generation of HR and EDI staff roles in every employment, you know, business in the country is frightening enough. But anyway, it's got nothing to do with their core businesses. And to note, the average salary of an EDI officer in the UK is £42,084. I also want to stress why an impact assessment must include an assessment on which occupations might be at particular risk of third-party harassment claims through no fault of the employer, and the impact specifically on free speech. And the reason I think that these parts of the amendment are very important is because we were asked earlier in a different group why there had been particular focus on hospitality, on sport and on universities. Well, maybe there are other sectors, but in a way, this is an assessment to see which sectors would be affected, and also it asks for an impact on free speech. And as we've heard, the government simply denies that there will be any impact in relation to free speech. Well, I disagree, but let's scrutinise it. The noble Baroness Chakrabarti made the point that we shouldn't worry about free speech because it's protected by, you know, the Convention on Human Rights, and she cited that, a number of clauses. And it is true that on paper, none of us should be worried about free speech. Our free speech in this country is fully protected. And yet, daily, more and more instances, as the noble Baroness Deitch, who's not in her place, indicated earlier, free speech is under stress in this country. More and more people are walking on eggshells and are, in many instances, getting sacked or getting disciplined for speaking their minds in workplaces. So I'm not convinced by this, nothing to see here, don't worry about it, all is well. Earlier, the noble Baroness...
I'm so grateful to the noble lady. I'll be brief, just to respond to her point, because she cited what I said before. I'm not trying to suggest that there aren't challenges and that there isn't, on occasion, over-policing of people's freedom of expression. I read the same newspapers, believe it or not, probably that the noble lady does. I guess the point I was trying to make, and perhaps inadequately, to the noble lord earlier, is that we have this overarching legislation in the Human Rights Act which guarantees free speech, and guarantees it in a way that is actually stronger legally and constitutionally than any amendment you could pass to the current Employment Rights Bill. And so if that's not working, then we need to enforce that better. But I'm just suggesting, as a matter of law, that we have the protection for free speech. We just need to enforce it.
Well, I'm all for enhancing the free speech duties required by the law in any particular way, and I'm happy to talk to the noble lady some at the moment about how we can do that. But for now, earlier the noble Baroness, the Minister, said that the government were on the side of workers, not the abusers, and she got a lot of hears. I'd just like to point out that the people who are worried about these clauses are not on the side of the abusers against the workers. I mean, that characterisation is not helpful, particularly in a committee in which we're trying to, in good faith, understand what the implications of this set of clauses are. But can you imagine if you're an employer and you hear that, oh my God, if I don't completely over-comply, I'm going to be accused, demonised, as on the side of abusers, not on the side of my employees. So I do feel that, I had more to say, but I've run out of time. I do feel that it's very important that this impact assessment is done, if anything, to reassure those of us who are worried, and if the government feel that we are over-worrying ourselves, then maybe a detailed impact assessment, which you hadn't had for these clauses of the bill, would help reassure us properly with facts and evidence rather than assertion and soundbites.